Thank you for being a part of the Paralegal Association of Florida's 2023 Annual Virtual Seminar. We commend the work done by our state's seminar committee to provide a seminar during this transitional time of post-COVID. My name is Michelle Ridge and I am president of the Big Bend chapter of PATH. It is my honor to speak with you today on behalf of the Big Bend chapter. Our chapter serves several counties in the Big Bend region and the Second Judicial Circuit of the state of Florida, which covers the capital of our state, Tallahassee. We kicked off this year attending a social event with the Northwest Florida Paralegal Association on March 9th in Panama City and met several stellar paralegals and attorneys in the Northwest area. Our chapter provides resources and opportunities to our members, including broadcasting employment positions through our job bank, charity events, and community service opportunities, with both intentions keeping in mind the personal comfort levels of our members. Our chapter has worked diligently to offer a variety of CLEs to our members and members of our sister chapters of PATH throughout the state of Florida. Our annual spring seminar on April 22nd returned to an in-person event, and we had several speakers and sponsors. The Big Bend chapter offers access to our board of directors meetings so that our PATH members receive the education and information about current events. We have also allowed paralegal students to attend our virtual events so they gain the insight to our association. Throughout the year, CLE announcements were sent to our members through P-mail, as well as posting them on our chapter's website at bigbend.pathinc.org and our Facebook page at Tallahassee Paralegals. Most recently, our chapter received a proclamation not only for October 23rd, the day, but for the whole week. The recording of the proclamation and acceptance speech is as follows.
Proclamation. Whereas in 1985, the Tallahassee Association of Legal Assistants was formed and later became a chapter of the Paralegal Association of Florida, Incorporated. And whereas the practice of law is challenging and complex, and paralegals provide a vital connection between lawyers and the clients they represent. And whereas attorneys require the services of knowledgeable professionals who are committed to fulfilling the duties of a paralegal. And whereas paralegals provide invaluable contribution to attorneys, governmental entities, and private corporations throughout Florida by drafting and analyzing legal documents, case planning, and legal pleadings. And whereas paralegals work to maintain integrity and a high degree of competence throughout the legal profession while striving for professional enhancement through education. And whereas paralegals are educated and trained with a thorough knowledge of legal concepts and facts and are experienced professionals with expertise in all critical aspects of successful and efficient law practices. And whereas the value of talented paralegals should be recognized for their great service to Floridians, now therefore I, John E. Daly, by the authority vested in me as the mayor of the city of Tallahassee, do hereby recognize October 23rd through the 27th as Paralegal Week and October 23rd as Paralegal Day, read into the record in front of each and every one of you here today, signed with my signature, dated October 11th, 2023. It is my honor and privilege to provide you with this proclamation. Absolutely.
Thank you for being present today for this special recognition of all paralegals by the City of Tallahassee. National Paralegal Day, October 23rd, is meant as a day to celebrate the ones who work selfishly behind the scenes, pushing the legal team to the best it can be, while truly advocating for our clients. We are all proud of our profession, and a little recognition goes a long way. Paralegals should be acknowledged and know that they are appreciated and that they are an important part of the legal profession and community. Appreciation for a job well done is said to improve work ethics, and today, Mayor Daley has ignited our recognition with this proclamation. We understand the privilege afforded to us to be at this public meeting and extend our gratitude. Our hope for the paralegals in our community is to receive acknowledgement by their employers, to bask in the spotlight shown upon us today. This proclamation reinforces how important paralegals are to our attorneys, our clients, and the community, and we are grateful for the honor bestowed upon us. The pride I have for my profession was emphasized in the language of this proclamation. I was reminded of the dedicated men and women who fill these roles in our community and how fortunate I am to work with them. Thank you again for this wonderful acknowledgement.
Hello, Judge John Miller graduated from Florida State University in 1983 with a Bachelor of Science degree in accounting. He then graduated with honors from the University of Florida College of Law. He was in private practice from 1987 until 2007 at the firm of Johnson, Green, Miller, and Gibson. He was appointed General Magistrate for the First Judicial Circuit in 2007 and served as a General Magistrate until 2010. In 2010, he was appointed as the Chief Judge for the First Judicial Circuit. Judge Miller presently serves as Chief Judge for the First Judicial Circuit, State of Florida. I'm happy to introduce Judge Miller.
Good morning. My name is John Miller. I'm the Chief Judge of the First Judicial Circuit in the state of Florida. I live and work in Pensacola, Florida. The First Judicial Circuit consists of the first 4 counties in the Panhandle, Escambia County, Santa Rosa County, Okaloosa County, and Walton County. Let me give you a little bit of background information about myself. I started practicing law in 1987. I was in private practice for 20 years in the Pensacola, Florida area. I was a litigator. I focused on different areas and practices of law over the 20 years, but over the course of 20 years, I was involved in criminal litigation, civil litigation, family law litigation, estate and probate litigation, did a little bit of bankruptcy. So I basically spent the 20 years of my practice in courtrooms, doing various things. I've tried a medical malpractice case to verdict. I've tried a death penalty case to a jury, and I've tried everything else in between. So I had a wide variety of legal experience. In 2007, I became a family law magistrate in the First Judicial Circuit and held that position for 3 years. In 2010, I was appointed by Governor Christ as a circuit judge and sat in Santa Rosa County for 5 years. And then I transferred over to Escambia County, and I've been over here ever since. I became chief judge 4 years ago in 2019, right before the pandemic. So I've been chief judge for the last 4 years. I currently preside in a family law division. Because I'm chief judge, I'm able to keep my calendar more flexible by presiding in family law. That way I don't have jury selections and docket days and jury trial weeks and motion days and things of that nature. My job as chief judge requires me to travel a lot to Tallahassee, to various committee meetings, and managing all of the courts in the First Judicial Circuit. So I am very busy, but it is my pleasure to be here today to speak to the Paralegals Association. We all know how valuable your roles are in the legal system. Anyone who has ever worked in a law firm knows who runs the law firm, who keeps it going, who keeps the clients happy. It's the paralegals and the legal secretaries and all the support staff. I've always appreciated the job you do. I've always felt like you have the most difficult job and the most difficult role of all of us. A lot of times you're underappreciated, but I appreciated you not only when I practiced law, but I appreciate you now as a judge. I was very fortunate during my time in private practice to have two excellent paralegals. I actually had more than two, but there's two that really stand out. I'm not exaggerating when I say that I probably would not be where I am today without both of the paralegals that I had in private practice. One of them is still with me. She's my JA. She wasn't my JA when I was a magistrate for 3 years, but she became my JA the day that I became a judge, and she's still with me to this day. I give you the background information for this purpose so you'll know that we remember what it's like being on the other side. We remember what it's like being where you are. We remember the challenges. We remember the frustrations. We remember what it's like trying to deal with judges' offices and other attorneys' offices and clients. And you have a lot of people pulling you in different directions at once. And we remember those challenges as well. What I'd like to do today is to give you my perspective of what I think you can do to have better communications with judges, better communications with your clients, and better communications with JAs. What I'm about to tell you is not universally adopted or accepted by the court system. It's one opinion from one judge on one day. Other judges' opinions may differ. As we all know, everyone in the legal system has different personalities. You have a lot of different types of judges, a lot of different types of lawyers, a lot of different types of paralegals within your own office and in other offices. And our job, whatever our role is in the system, is to try to get along with everybody to promote justice as best we can. Let me start with effective communication with judges. I'm going to get right to it. Whenever you send something to a judge, whether it be a proposed order, correspondence where you want the judge to take action, send a cover letter. I'm going to use proposed orders as an example. Don't just send an order. There's nothing more frustrating than for my JA Susie and I to get an order out of the blue with no cover letter, no explanation, and we look at it and say, what is this? And we have to go and dig into the file and figure out what it is. Now, you're probably thinking, well, it should be obvious to you what that is. And a lot of times that may be true. For example, right now I'm in a family law division. And if I have a temporary hearing, say on Monday of this week, on October the 30th, and you send me an order today, which is November the 2nd, I'll remember that. I'll remember what it is. I'll remember the attorneys. I'll remember what the case was about. And I can probably look at it and go back over my notes and sign it. But I have a lot more than one case. And not everybody sends orders promptly. Sometimes they come in weeks after the fact, sometimes months, unfortunately, but they do. It is so helpful if you will just simply send me a short cover letter. It doesn't have to be long, saying, Dear Judge Miller, enclosed herewith, please find a proposed temporary order. You conducted a hearing in this matter on October the 30th. You instructed us to prepare a proposed order. Here is the order. Should you find everything satisfactory, please execute the order. That way I'll know where the order came from, who it came from, what it's about, and what you want me to do with it. Suppose that we didn't have a hearing and you want to send me an order without the necessity of a hearing. Let's suppose that it's an order admitting will to probate. Let's suppose that it's a motion for judicial default. Let's suppose that it's a motion to compel discovery in a civil case. I've sat in all those divisions and dealt with all different types of orders. So we have a motion to compel in a civil case. Dear Judge Miller, enclosed you will find a proposed order compelling discovery in the above referenced case. Please review the proposed order. Should you find everything satisfactory, please execute the order. Should you find a hearing be necessary in this matter, please advise. That tells me that I haven't had a hearing in the matter, that you want me to sign the order without a hearing. Sometimes I'll do that, sometimes I won't. But what you've just done is laid it out, and I don't have to look at an order without a cover letter and wonder, did I have a hearing on this? Did I not have a hearing on this? What am I supposed to do with this? It saves us a lot of time. And the bottom line, by sending a cover letter, you're going to get your order signed a lot faster if you can guide us in the right direction up front. Whenever you send the proposed order, you always copy the other side. Obviously, you can't send ex parte communications to the court. Anytime you send something to a judge and you want me to do something with it and take action, the other side has to have a copy of it and they have to know that it's being sent to me. So by sending the cover letter, you let me know that you've copied the other side with it. I don't have to wonder that. My JA doesn't have to get on the phone and say, hey, did you copy opposing counsel with this? We already know it. It's in your cover letter. It's CC at the bottom. It also tells me, just as importantly, when you sent the proposed order to opposing counsel. Did you send it yesterday? Did you send it 2 or 3 days ago? Did you send it a week ago? Did you send it a month ago? Have they had time to look at it? So you always copy opposing counsel with your correspondence and with your proposed order. I think it's a good idea as well to always copy your clients. That's not something I'm involved in or really care about, except I think it's good business practice on your part. Your client gets that in the mail, whether it be an email or a formal letter or what. And the client says, hey, we had a hearing the other day. They've already got this to the judge. They're sending it to the judge. That way your client doesn't call you and say, has the judge signed the order yet? Or have you sent the order to the judge yet? Or when's he going to sign it? That is a good way for you to communicate with your clients without calling them or emailing them. Just copy them with your correspondence. The next topic is the preparation and submission of proposed orders and pleadings and correspondence to the court. I speak to young lawyer groups all the time. I speak at bar events, at CLE events, at seminars. And one thing I constantly tell lawyers is what you put in pleadings and correspondence and proposed orders, your written communication with the court is more important and actually makes more of an impression on a judge than your oral presentation in court. A lot of lawyers don't believe that, but it's true. And I'm sharing it with you because paralegals play such an important role in what is submitted to a court. So I thought I would share these thoughts with you. I go back to when I first started practicing law back in 1987. Within a year or two of that, I became involved in a case. I think we represented Prudential in an insurance defense claim. It's a fairly complicated case where someone was suing Prudential because an elderly person felt like they were sold an annuity or something that was too risky for their age. I didn't do a lot of insurance defense as a lawyer. When I practiced in the civil arena, it was on the plaintiff side. My wife is an insurance defense lawyer here in Pensacola, so she does all of that actually exclusively is what she does. So I'm very familiar with it. But what little insurance defense I did, I was always amazed at the packet that they would prepare in advance of the suit and send it to the attorney, to the law firm that they retained. One thing that stood out in this case was the complaint that the plaintiff's attorney had drafted. He was a very good, experienced attorney, Very well drafted, well stated, well reasoned complaint. You could tell he put a lot of thought and effort into it. And in the initial evaluation that was sent by Prudential to us, one of the things that really stood out to me was how much they raved about the plaintiff's attorney. They said, you know, this is somebody that really knows what he's doing. This isn't somebody that just stumbled into this and is hoping to file a suit and get a quick settlement. This guy is serious. I've never forgotten that. And I think the lesson carries over to every type of written communication that you have in the legal system. People form an impression of you based on your written communication, based on what you send out and what your lawyer sends out. And I've got to say that there are several times each week when I'll review a pleading or I'll review a motion or I'll review a proposed order or other type of correspondence, and I'll say to myself, you know, he really knows what he's doing, or she really knows what she's doing. There are other times I'll get something, whether it be a motion, a proposed order, whatever, and a thought will go through my head like, she really didn't put a lot of effort in this or thought into this, or he really doesn't seem to care a lot about this. Now, I realize as paralegals, you don't have ultimate control over what goes out of your office, your attorneys do. But I think it's important that everyone understand that everything that goes out of your office that your name is on or your attorney's name is on, people are going to form an impression of you based upon that. And sometimes that impression is going to stick. When you're asked to do a proposed order, number one, do it promptly. There's nothing more impressive than for me to get an order back on a hearing that I conducted yesterday or the day before or shortly before that, or the same day in a lot of cases. Sometimes I'll have a hearing in the morning, I'll come in the afternoon, I'll look at my box. There's an order in the box. Dear Judge Miller, enclosed herewith, please find a copy of, or please find a proposed order that you instructed me to prepare at the hearing this morning. Should you find everything satisfactory, please execute the order. Very impressive. It shows me somebody takes this seriously. They went back to their office, they drafted an order, and they sent it to the court immediately because they want it signed immediately. There's nothing more frustrating and more less impressive than for me to conduct a hearing in any arena, civil, criminal, family law, whatever, and for me to get an order 4 or 5 months later, or for us to have a subsequent hearing. I'm still waiting on an order that I had from an earlier hearing, and I asked the attorney, where's my order? Oh, well, Judge, we forgot to do that, or that one fell through the cracks. Is it possible that things fall through the cracks with busy schedules? Yes, it is. Should it happen frequently? No, it should not. So please do the orders promptly. Take pride in your work. It impresses me, and it impresses anyone that reads your pleadings and correspondence, for you to have pleadings and correspondence and orders that are well drafted, well reasoned, proofread, spell checked, good punctuation, good grammar. I honestly will tell you that I get things that won't pass 9th grade English, and I'm not exaggerating when I say that. The best arena is circuit civil. Usually everyone there does pretty good work, good pleadings, good motions, good orders. Family law, it depends on the attorney. Some are very good. Some are not as good. Some are poor. Probably the worst is criminal. When I used to sit in criminal, I would get some things that are pretty good. I got a lot of things that weren't. Let me give you an example. We would have a bond hearing, for example. Somebody would want me to lower their bond. I would lower their bond, say, from $20,000 down to $5,000. I would get an order. It would be a few days afterwards. Instead of just saying your bond is reduced to $10,000, it would say, the motion to reduce bond is hereby, then there would be a box granted, then a box denied. You could tell there wasn't a lot of thought put into that. And I know that different lawyers do things different ways, and it may not be your responsibility. When I practiced law, I did all my own orders. I used a dictaphone. What I would do as soon as I left the courtroom, I would go back to my office. I would grab my dictaphone. I would write then, dictate my order. Paralegal would type it up. I would draft a cover letter. I would send it. I realize not all lawyers do that. A lot of them, and you can tell the ones that do, would go back. They would take the file. They would throw it on someone's desk and say, "Here, figure out a way to do me an order." So different lawyers have different styles, different ways of doing things. But whether your lawyer drafts it and you proofread it, or you're the one that drafts it or whatever, just dot your I's, cross your T's. Take pride in your work because, like I say, it forms an impression of you. If you prepare an order, please don't put things in the order that I did not say or rule, or add extra things, or add verbiage, or take shots at one of the lawyers or one of the parties. Put the substance of the order in the order. Don't put anything else in there. If you want to add something because you think I left something out or forgot something, every now and then that's permissible, but tell me you did that. Let me give you an example. If I have a hearing today, say it's a child support hearing, and I order an amount of child support, but I forgot the start date. This is November 2nd. So normally I would say child support starts the first day of each month. I would say it starts December 1st. Say I forgot to say that at the hearing. On something like that, I see nothing wrong with you putting that into the order, send a cover letter, say, "Dear Judge Miller, enclosed you will find my proposed order. You inadvertently forgot to put a start date for the child support. I put December the 1st. If you find that satisfactory, please sign the order." If you object to a proposed order that's submitted by the other side, the best way to do that, if possible, is to submit your own proposed order. That's not always possible, I understand. If it's a 20-page final judgment of dissolution of marriage and you're objecting to a couple of things, you don't want to have to go and redraft the entire order. But if it's a short, concise order, a page or two, if you'll just submit your proposed order, it's a lot easier for me than to go back and try to reconcile all the different drafts and versions. That's not always possible. I do understand that. Another option now is my JA Susie a lot of the time will request that you submit the proposed order in Word. And so if there are some slight changes or revisions that you want to make, sometimes we can do it in Word, but it's a lot easier if you just submit your own proposed order. Emergencies. Many times you're going to request a judge take emergency action in a case or set a case as an emergency. I do not have a block of time on my calendar that we designate for emergencies. I know some judges may. It's difficult for me to do that as chief judge because I'm so busy with chief judge duties. I have a family law docket. I'm supposed to not to have a full docket. It's only like a 2/3 docket. But all that really means in family law, your docket's full all the time anyway. To have a reduced docket, all that means is you may get a hearing in 4 weeks rather than 6 weeks, or 6 weeks rather than 8 weeks, or whatever. But my calendar stays full, so I don't have designated blocks of time for emergencies. That being said, there are legitimate emergencies that I need to deal with. I do schedule emergency hearings. I have to find a way to squeeze them in and fit them in as best I can. But a lot of the time, what you think is an emergency, I may not consider an emergency. For example, in a family law case, not paying the property taxes is not an emergency in my mind. Somebody that may take the child out of state permanently without filing the proper pleadings, that I would consider an emergency, something like that. But a lot of times we may differ on what is an emergency and what may or may not can get in as an emergency. So if you want to set something as an emergency or want any judge to take emergency action, you need to be able to communicate to the judge why you think it is an emergency and specifically what you want the judge to do about it. Do you want the judge to set a hearing? Do you want the judge to enter an emergency injunction? What do you want to do about it? And you need to be able to communicate that to the judge clearly and concisely in writing. If you are seeking any kind of injunctive relief, you need to make sure that you familiarize, or your attorney familiarizes himself or herself with the rules. There are certain formalities that have to be adhered to when seeking injunctive relief. For example, you have to plead irreparable harm. In most cases, you have to have a sworn complaint. It has to be notarized or sworn to, and it's submitted to the court. I've gotten requests for an emergency injunctions before that I would be inclined to grant, but they were not in the proper form. So when you submit that type of requested relief to the judge, make sure that you familiarize yourself with the rules and make sure that it's in proper form. Ex parte communications. As we all know, you're prohibited from having any type of ex parte communications with the judge. When we think of ex parte communications, the first thing that comes to our mind is, all right, we're going to lunch one day. We walk into a restaurant. There sits an attorney. The attorney is going to have a case on my docket in the next 2 or 3 days. The attorney waves over, says, hey, judge, why don't you come and sit down and have lunch? I got a case coming up on your docket. Why don't we talk about it? Let me give you some information. We all know that I can't do that. And I don't know of any lawyer or paralegal or anyone else that would even attempt to do that. But that's what we all think about when we hear the term ex parte communications. There are other forms of ex parte communications that we have to watch out for that are a lot more subtle. As a rule of thumb, here's what you need to know. Anytime that you are asking a judge to do something, to take any type of action in a case, the other side needs to be aware of what you're doing and what you're asking for. Now, that doesn't mean that you can never communicate with the judge's office without the other side on the line. The rules of judicial administration provide that scheduling hearings and talking to court staff, court personnel is not a form of ex parte communication, because it does not involve the judge. It involves you and the JA, or you and the case manager, or you and whoever. I had a high-profile criminal case many years ago. We were at one of the pretrial hearings, and the issue came up about scheduling a motion. And it came out that the state attorney's office assistant contacted my JA to get some dates to schedule a hearing. The defense attorney says, Judge, that's improper ex parte communications. We were not involved in that. And then I said, I know you were not involved in it, but I wasn't involved in it either. Therefore, it is not ex parte. Now, how can it become ex parte? Let me give you an example. We have a temporary hearing in a family law case coming up later in the week. It's a motion for temporary alimony, temporary child support. Suppose you decide that you also want your motion for temporary attorney fees to be heard at the same time. And you contact my judicial assistant, whether by telephone or email or whatever, and you say, hey, Susie, we forgot to notice the motion for temporary attorney fees. We'd like to piggyback that on to the child support and alimony, because it's the same issue, really. It's money, and do they have the ability to pay? And I don't think anyone's prejudiced. Why don't you go ask the judge if we can do that? Can't do that. If you do that, you need to send an email and you need to copy the other side. And you need to say, we would like to also schedule our motion for temporary attorney fees at the same time. See if Judge Miller thinks that that's appropriate, if he will approve that. That way, the other side is on notice of what you're doing. They have an opportunity to object and say, no, we don't want that motion heard at the same time. It's late notice, we're prejudiced. Or they can consent and say, sure, we'll all hear it at the same time, so we won't have to come back. That's not ex parte. And the difference is in the latter example, you've notified the other side, they know what's going on. You're asking the judge to get involved and do something. The other side has a right to know what's going on at every step of the way. So they have an opportunity to object. Now I want to talk about effective communication with judicial assistants. As I mentioned to you before, Susie was with me in private practice for many years, and before she worked with me, she was in the business for many, many years. So we know what it's like on the other side. We know the challenges you face. We know the difficulties you have. When it comes to scheduling, number one at the top of the list is be available. If we call you to schedule a hearing, please answer the phone. Please be available. We're available when you call us. When I first became a judge back in 2010, Susie and I sat down and we talked about the things that we did not like from certain judges' offices and the things we did like from judges' offices. And one thing that Susie told me, and I agree with her, she did not like judges' offices that would not answer the phone. So we decided we're going to answer the telephone when you call us. If we don't answer it right when you call, we will call you back. We will make that promise to you. I realize it may not be that way with all judges. I do understand that, but most judges will at least perceive that they try to be available, or their JAs do. And just about all of them will want you to be available when they call. There's nothing more frustrating than for someone to call to set a hearing. We get the opposing office on the phone. I don't know if we can set this or not. Let me talk to my attorney, call you back. Okay. But then we call back the next day and the next day. And with the case volume that we have and trying to schedule so many hearings, it is so frustrating and so time consuming when we cannot get people on the phone and we cannot get people to call us back. It's a two-way street. You want us to answer the phone when you want your hearing scheduled. You want us to sign your orders when you send them over. If we're going to cooperate with you, please cooperate with us. What if you have a problem scheduling a hearing? I can't speak for all judges, but I can tell you what I do about it. If you persistently call and try to schedule a hearing on a case and you're not getting cooperation on the other side, this is what we do. Susie keeps a log of every attempt she makes or every email she sends, every attempt she makes to schedule. She makes 3 attempts, phone calls, emails, or whatever. She doesn't get a satisfactory response. She brings the file to me and say, look, I've made 3 attempts. I called on Monday, I called on Tuesday, I called on Wednesday. They will not call us back. They will not communicate. What I then do is I draft a letter to both counsel or to the parties if they don't have counsel and say, Dear Attorney X, Dear Attorney Y, my judicial assistant has been trying to schedule this matter for hearing. She has not been successful. Therefore, I'm going to set a scheduling conference next Monday morning at 8 o'clock. I would like both attorneys to be in my office with their calendars. I'm going to set your case for hearing. I'm going to determine what is a conflict and what is not a conflict. Now, if you can set this for hearing before Monday morning at 8 o'clock without my assistance, then I'll let you cancel the hearing and you don't have to be here at 8 o'clock. I've only had to send that letter 3 or 4 times since I've been on the bench. And every time but one, they were able to satisfactorily set the hearing. I actually had a case years ago where somebody showed up in my office with their calendar at 8 in the morning and said, I've decided I don't have an objection to setting this. But most people get the message when I send the letter out. People know that I will send the letter out, and most of the time they're cooperative with my office because they know that that's how we're going to do things. So we're going to be cooperative with you. Please be cooperative with us. What do you do when you deal with difficult offices and not only scheduling hearings, but depositions and other things? You can ask the court to take action. I know that sometimes that can be very frustrating as a paralegal or as an attorney when you're trying to get something said and there's someone that just won't consistently cooperate with you and you wonder why we don't do more. Let me tell you this, and I say this to lawyers all the time. We see a lot more than you think we see. We know who cooperates. We know who doesn't cooperate. When if I get a complaint about a certain office, a certain attorney, and that's the only complaint I ever hear, okay. But when I start getting complaints from lots of different attorneys and offices and from my own JA about who's cooperative and who's not, we get the point. We see a lot more than you think we do. So why don't we do more about it? Why don't we call them out about it? A couple of reasons. Number one, it's a great way to get recused if you do that. If I call somebody in and say, hey, Attorney X, Attorney Smith, I think your office is uncooperative. I think you're unethical. I think your paralegal's being uncooperative too. That is a great way to get me off the case and get recused. Number two, a lot of times when it comes to unethical conduct and uncooperative conduct, sometimes it's not as much of a bright line as you think it is. I suspect it in a lot of cases, but I don't absolutely know it enough to say it or call it, but I suspect it. Number three, at the end of the day, my role and my job is to try each case on the merits as best I can. The procedure, everything that gets to the merits of the case is a means to an end. And the bottom line at the end of the day is for me to decide the case on the merits. And that's what I try to do in every case. But we are aware of the problem. We are aware that it goes on with certain offices, and we do try to do what we can. When you're dealing with judicial assistants, the next tip is be courteous, be nice. When I practiced law, I assumed everyone was that way toward JAs. I assumed everyone was courteous, everyone was nice. I can tell you they're not. It's not, I don't say it's common, it happens. Susie will get a call at 8 in the morning and say, I need to set a hearing, or I need you to look for an order for me, or whatever. Okay, I'll look into it. An hour and a half, 2 hours later, she'll get a call. Well, are you going to respond? Or she'll get a snarky email. Why haven't you helped me with this? What about this? What about that? I think one of the problems is modern day communications. Back in the old days, before we used emails, we did everything by telephone. People were a lot more civil on the phone. It's easy to sit down in the middle of a hard day and send off a snarky email or one that's less than courteous. But be courteous. JAs are human. They want to help you, but they're courteous. I mean, they're human. If you treat them with respect and dignity, I can't tell you the number of times Susie may tell me during a given month, I really like Paralegal Smith, or I really like Paralegal Jones, or she's so nice, or Attorney Smith's office is so nice. They're so helpful. This is the person you're calling to schedule hearings, to get orders signed, get other things done. Be courteous, be nice. Now, I can tell you from my perspective as a judge, it's not going to affect how I rule on your case. The fact that you're rude or discourteous to my JA, at the end of the day, if the law and the facts are on your side, I'm going to rule in your favor. If they're not on your side, I'm not going to rule in your favor. It's as simple as that. I liken myself to, I always use a baseball analogy. I watched the World Series last night for a little while, and I thought of an old baseball analogy. There was a baseball manager named Earl Weaver that used to manage the Baltimore Orioles in the old days. He had a running battle with an umpire named Ron Luciano. Their battles were legendary. They hated each other. Earl Weaver used to publicly accuse Luciano of cheating for the other side and against his teams. And one day somebody asked umpire Luciano, do you cheat? Do you have a bias? Do you try to cheat Earl Weaver's teams? And he says, no, I don't. I've been doing this for 20 years. There's 162 baseball games in a year. There's approximately 200 pitches per game, sometimes more. When you do that over the course of 20 years, that many pitches, you're just programmed. If the ball crosses a certain part of the plate, you automatically hold your right hand up, strike. If it doesn't, if it's out of the zone, you call it a ball. The pitch comes so fast, it happens so fast, it's so routine. You're used to doing it. You follow your instincts, you follow what to do. You don't stop and think, now, wait a minute, here's this pitch. Let me think about it. Who's managing this team? Who's managing that team? Who's at bat? What's the count? What's the situation? You don't do any of that. You just call balls and strikes. And actually, that's what a judge does. We call balls and strikes regardless of the sideshows and what goes on. So it really is not going to affect how I rule in a given case, how you treat my JA, but I think you'll get a lot more out of them the more courteous you are to them. Let me discuss some things that JAs are not interested in doing. They're not interested in getting into squabbles between you and other offices. Usually when you have a problem with another office, it's not just one case. It involves a lot of cases. Sometimes people will call and say things like, I have a problem with her in every case. This is an ongoing problem. They won't deal with me. The JA really doesn't want to hear that. What they want to do is deal with a case that we need to deal with in our division at the time. As a general rule, watch gossiping about other offices, about other people in your own office. Sometimes we hear that from people we don't even know. Every legal community is actually a small community. The reason I say watch gossiping, it's not like I'm just morally against it. I love a good story as much as anyone else. But in the legal community, what you're going to find, and I learned this a long time ago, you never know who is friends with who in the legal community. That's lawyers, that's judges, that's paralegals. And you never know who may not be friends today, but who will be friends tomorrow. I've been amazed at how often I've seen that happen. Lawyers at certain firms that have a difficult time with lawyers in other firms, and then the lawyer joins the other firm. More common with paralegals, actually. Paralegals in one office can't get along with other offices. Next thing you know, they're working for the attorney at the other office. You never know what you're going to say is what you're going to say is going to be heard by somebody that you don't want to hear. So watch what you say. It's going to come back and bite you in the long run. The other thing that judicial assistants don't want to get involved in are your personal opinions about cases. Susie will get calls a lot. We really need to get this in for a hearing. My client is just the best father, and the mother will not allow him to see that child, and we just don't understand it. Or we really need to get this into court. My client needs child support. He hasn't paid her in so long. Or we don't understand why Judge Miller needs 3 hours for this hearing. This guy should not be paying alimony. The judge should be able to terminate his alimony in 30 minutes. You have to understand that you sympathize with your clients, you rationalize with your clients, you come at this from the perspective of your client. So does the other attorney, so does the other paralegal. So Susie doesn't want to get involved in your personal opinions or in arguing the merits of the case with anybody. Be reasonable in your time request. We have a busy calendar. We try to get hearings scheduled as quickly as we can. It is not always possible. We have big caseloads. And on top of that, especially now that I'm chief judge, a large part of my time on my calendar has to be devoted to chief judge duties. So even though I may have time available, unfortunately, I can't do family law hearings during that time. I have to devote my time to chief judge duties. We do try to get everyone in as quickly and as efficiently and as we can. And I have to prioritize who gets in when. So be reasonable with your time request. Have your lawyer evaluate what you're seeking for. Do you really need 3 days or do you really need 2 days? I've had hearings before that I noticed were set for an hour to compel a financial affidavit from a pro se litigant. I generally give attorneys and paralegals a lot of latitude, and so does Susie in scheduling time. We generally give you whatever time you ask for. And the reason is when I was an attorney, it would be frustrating the judges that did not do that. Some judges had to approve each case that was set and had to approve the amount of time, and it's an ordeal just to get everyone on the phone or everyone on the same email chain, get a time, schedule the time, and then you can't get the time because the judge has to look at it first and get back to you in a few days. So for that reason, we give a lot of latitude to you in how long you want to schedule a hearing for, and we try to defer to you on that, but try to be reasonable in all your requests. We ask that you do file your motion before you schedule a hearing on the motion. If it's not already filed, it should be filed within just a few minutes of your request. I remember one time I practiced law, and there was a common practice actually back then on summary judgment motions in civil cases. You have to have 20 days notice. Here, it couldn't be heard in 20 days, so they would set a hearing 3 months out or 4 months out. But they would wait to file the motion 20 days, so you would have less time to respond. We don't allow that. You've got to have the motion filed when you want to set your hearing. Another reason is, like I say, we have busy calendars. I've seen it occur before where someone would call to set an emergency motion on something, we would set it, and then they would never file the motion. And then they would say, well, we didn't have to do that. It resolved itself. Nobody would call us or anything. So we do insist that you file the motion before you set the matter for hearing. There is a movement to online scheduling now, which I think is intriguing, which we're going to experiment with in the First Judicial Circuit as well. I know it's already been done in some jurisdictions. I believe in South Florida and Dade County. They've had the program for a while, from what I understand. I'm anxious to try the program. It's where you can go online and look at my calendar and get blocks of time and go ahead and pick your dates. And if you can coordinate it with the other side, go ahead and schedule your motion and let Susie know. I think that is a great idea. Now, I got to say this, I'm not going to turn over my entire calendar to anybody. I just can't. I'm not saying that to be condescending or arrogant or selfish, but it's just the reality of the world I live in. I'm not going to give complete control over my calendar. When we go to online scheduling, my understanding is there are restrictions that can be placed on it. In other words, I may not set 2 and 3 day finals online. I'll let somebody look at dates, but I won't let them set it. It may be limited to setting hearings for 30 minutes, 15 minutes, an hour, however we want to program it. But that is something we're going to look into in the future. Effective communication with clients. Let me preface this by saying I am glad that I do not practice law in the year 2023. I enjoyed doing it when I did it. The 20 years I was in private practice, the memories I had from that, I would not trade for anything. The cases I tried, it's full of highs and lows. It's a roller coaster, but I would not trade the memories for anything. I thoroughly enjoyed doing it, and I was glad I was able to do it. But I'm glad I don't have to do it today, and here's why. When I practiced law, in the beginning, we did everything by paper. This is before we even had email or internet. Around the mid-90s, late 90s, I believe, all right, here comes the internet. Then we started using email more and more. That was great. I'm not knocking modern day technology. It's much more efficient. But the way that we operated is someone would call me, my paralegal or legal assistant would leave a message, put the message on the desk. They would be in a stack. I would pick them up. I would call them. I would call the client back, whatever. That's how we operated. I'm glad I don't have to practice law today because of email. When I did practice law and we had email, my personal policy is I would not communicate personally with the clients by email. And the reason is I could talk to them on the phone. I could answer their questions. I could make sure I addressed all their concerns. What I was afraid of if I answered email is every time a client got a wild thought, they would send me an email. In a PI case, how much money am I going to get out of this? How do you evaluate it? In a criminal case, how much time am I going to get? In a family law case, do you think I'm going to get custody of the kid? I don't want a duty to have to impose a duty on me to sit there and type out a response to vague, really broad questions like that. So I'm glad I don't have to deal with that aspect of it today. Too much technology can be a bad thing because it creates unreasonable expectations. And if I would respond by email, I would be afraid that I would leave something out, that I would be busy, that I would not give a complete answer, that I might get sued for malpractice later on or get a bar complaint later on because I didn't completely answer the question. So I'm glad I'm not sitting where you're sitting today. That being said, technology is a great thing, and it has created a lot more efficiencies. Tip number one with clients, return their phone calls. I've served as a bar referee before in certain cases. I've never served on a grievance committee, but I've talked to a lot of people who have throughout the years, and they tell me the number one complaint that they get about lawyers isn't that they botched their case or they botched the verdict or they botched the result. They will not return phone calls. They will not respond to correspondence. I realize as a paralegal, you may not have complete control over that. The lawyer may. Your lawyer may have certain restrictions over what you can and can't do and what you can and can't say and how can you respond and so forth. But communicate with your clients. That's the most important thing that you can do. It can save your lawyer a lot of time, heartache with bar complaints, malpractice suits, things of that nature. Copy your clients with everything. I've mentioned this before. It is a great way to communicate with your client without having to talk to them. It lets them know that you're working on the case without you talking to them. You get a letter from the opposing counsel, other side. Just CC your client with them. You know, you can do it by email if that's how you communicate. Anything that you file with the court, any pleading, any cover letter, any correspondence, copy it to the client. It lets them know you're working on the case. That way, when they get the bill at the end of the month, they know what you did. They can see that already. You're not going to get a call saying, what do you mean this, this, and this? Well, they see it. You've already sent it to them. It's a great way to communicate. It also is a great way for them to help you plan strategy because they see what's going on and they'll go ahead and start taking notes and think of things that they need to talk to the lawyer about or to you about. I do realize that your job involves a lot of hand-holding. There are certain intangibles that paralegals and legal assistants have that are just invaluable, and hand-holding is one of them. Like I said, I had two of the best in the business that were great at that. You know, I would deal with the legal side of things. They would deal with most of the hand-holding. It's really rare and hard to find a paralegal or a legal assistant that has the skill to do the hand-holding and also has the clerical skills at the same time. Sometimes I've had two great ones that can do both, but I've had some that could do one or the other. I had one time, from a clerical point of view, she was the best in the business. I mean, but the problem was she wasn't very good at hand-holding. She was just the opposite. And I was afraid, you know, she ended up leaving for another job on her own. But had she not done that, I was afraid I might not have had many clients left at the end of the day because she wasn't good at that aspect of it. But I had another one time when I first started out a long time ago, who was a great hand holder, was a great personal skills, absolutely enjoyed working with her. She was a pleasure. She did not have good clerical skills. And I would constantly have to go back and redo and redraft a lot of things. And actually, it probably did me a favor because that's where I learned to use my dictaphone and to do everything myself and dictate it to start with. And that got me into some good habits. So actually, that probably wasn't a bad thing at the time. But hand-holding is part of your job. I hope that what I've said today has been helpful. I've really enjoyed preparing this. It brought back a lot of memories from a time as a judge and time as a lawyer. There is one thing off topic I'd like to talk about because I think it's relevant to all of you. In the First Judicial Circuit, we were the victim of a cyber attack on September 29th, 2023. It shut down our entire system throughout the First Circuit. It got our computers, it got our phones, it got our court smart recording devices. It got everything. We have worked to rebuild it very diligently. Our IT team has just done an amazing job. We've gotten a lot of help throughout the state of Florida from the other circuits, from IT departments. OSCA in Tallahassee, Office of State Court Administrator, Florida Supreme Court, everyone has been helpful in getting us rebuilt and back up to speed. The reason I mention it to you is this. One of the complaints that I've gotten from paralegals is they've lost, not from paralegals, from JAs, is they've lost a lot of their stuff. Some of it we're recovering actually, but they lost a lot of, my sample orders, my templates, proposed orders, things that they use, jury instructions, things they used on a daily basis. And it's frustrating. We're rebuilding it, we're redoing it, and we're getting some of it. But one thing I want to stress to each of you, this cyber attack was a professional hit. It was an international attack. They not only have hit court systems throughout the country, they've hit a lot of law firms throughout the country as well, some in the state of Florida. So all of us, whether you work in a courthouse, in a law firm, sole practitioner, big firm, you can be the victim of a cyber attack. What I encourage all of you to do, we all have a backup system. Everybody has that. But in addition to your regular backup system, if there are things that you cannot live without, and you can't live without them, personal things, wills, personal correspondence, whatever, use a thumb drive to back up in addition to the backup system that you have. Some of the judicial assistants did that. Some of the judges did that, and they're very glad that they did that today. So I will leave you with that as my parting tip of the day. I wish you all luck. And if we have cases with my office, me and Susie look forward to working with you. Thank you very much.
Good afternoon, and thank you again for joining us. We hope you were able to take a little knowledge, insight, or clarification from today's presentations and to obtain a little more appreciation for all they do to keep the system in balance. Please remember that the CLE request forms will need to be returned no later than November 22nd or once you have reviewed the take-home sessions to the email provided. Upon completion, you will then receive the NALIS certification of attendance. Should you have any questions or need further information, please do not hesitate to reach out. At this time, I'm sending you off with wishes for a wonderful evening and a great weekend. Sincerely,